Item 2, Constitution of the Republic of Singapore Amendment Bill.
Minister for Law.
Mr. Speaker, I beg to move that the bill be now read a second time. Sir, this bill is related to the next bill on the order paper, the Judicial Service Miscellaneous Amendments Bill, which will make consequential changes to various acts arising from the amendments to the Constitution. Sir, may I have your permission for the debate on both bills to take place now? There is substantial overlap to both. Members can raise questions or express their views on both bills during this debate, and we would still have the formal second reading of the Judicial Services Miscellaneous Amendments Bill to ensure that the necessary procedural requirements are dealt with.
Please do.
Thank you, sir. Sir, this bill makes several amendments to the Constitution to restructure the Singapore legal service. In essence, the bill will establish a separate judicial service overseen by a new Judicial Service Commission, or the JSC, and make consequential changes to the legal service, which will be overseen by a reconstituted Legal Service Commission, or the LSC. We have consulted the President on the amendments, some of which affect her discretionary powers. The President supports these amendments. I will begin by briefly touching on the history of the legal service. It will give members some context for the changes being proposed today. The framework for the legal service was established by the 1959 Constitution, which marked Singapore's transition to internal self-government. Over the years, adjustments were made to the way the legal service was run. But the fundamental structure remained unchanged for many decades, until two rounds of major changes. In 2007, a comprehensive review was done. Major changes were made to create a more systematic talent management system. There were two key changes to the constitutional structure. First, the composition of the LSC was expanded. Since independence, members will know that the LSC had comprised the Chief Justice, the Attorney General, the Chairman of the Public Service Commission, or Chairman PSC, a Supreme Court judge, and two members of the PSC, as nominated by the Chairman PSC. Unlike today, all of the members of the LSC were members by virtue of some other office that they held separately. The 2007 changes widened the LSC's membership. The CJ, AG, and Chairman PSC would continue to be on the LSC. But in addition, up to 6 additional members who need not be Supreme Court judges or PSC members could be nominated by the Prime Minister, the Chief Justice, and the Chairman PSC. The rationale was to bring in members, including those from the private sector, with a wider range of experience, for example, in personnel management, or who have knowledge of the legal service or the legal profession. A second key change that was made then was to put in place a system of autonomous personnel boards, or PBs, which would have charge over different classes of LSOs, and I'll cover this in more detail later on in my speech. The second major change happened in 2014. There was a significant shift in favor of specialization in response to the increasing scope and complexity of legal work. 2 separate career tracks were introduced for the LSOs in the middle ranks, the judicial and legal tracks. LSOs in the middle ranks could elect to specialize along either track. They could be posted to jobs within either the judicial or the legal branch to build experience. The PBs were also restructured along the branch lines to oversee the career development pathways of the LSOs in the respective tracks. The enduring challenge has been our very small pool of talent due to our small size. This has been the raison d'etre for keeping with an integrated model. LSOs could be deployed interchangeably across judicial and legal branches over the course of their career. This principle was in fact recognized very early on. In the 1955 Malayanization Commission, which was set up to accelerate the pace of localizing the public service in preparation for self-government, recommended that legal service officers be transferred from the judicial side to the legal side and vice versa, so as, and I quote, to give officers an all-round training and also to overcome the present objection of potential recruits to having experience limited to one side of the service only, which leads to a monotonous and incomplete professional career. It was also agreed that all-round experience was beneficial and that it would be best for officers to have experience at the bar, on the bench, as well as in the Attorney General's department. At the time of independence, we only had 45 legal service officers. It took 30 years for the legal service to grow to 235 LSOs in 1995. This number then grew significantly to 589 LSOs in 2014. But even then, a fully specialist service was not a viable option. There were only 159 officers in the judicial branch and 419 officers in the legal branch. With these numbers, having specialist services will leave officers on the judicial side especially lacking in opportunities for growth and career development, an incomplete professional career, to quote the words of the Malayanization Commission. This would hamper the ability to attract and also retain talent. So the integrated model has worked well for our context. The legal service has played a key role in the development of our legal system and consequently in building Singapore's reputation for commitment to the rule of law. As former Chief Justice Yong Pa Hau said previously, the legal service has played a very important role in the success which Singapore has achieved as a nation. The work of many legal service officers has contributed significantly to the recognition which our legal system has obtained as being amongst the best legal systems in the world. Today, over 800 LSOs serve in various crucial roles. LSOs in the judicial branch have contributed to building a world-class judiciary that is both strong and trusted. LSOs in the legal branch, such as in the Attorney General's chambers and in the various ministries, support effective and nimble functioning of the executive and parliament. For example, officers in AGC's legislative division not only draft all the laws that are tabled and debated in this House, and I'm sure members are very familiar with all the bills that have come, sometimes at breakneck speed, but also many pieces of subsidiary legislation that are critical for the effective functioning of the executive. Our international lawyers, they defend Singapore's interests on the global front and make an outsized contribution to the continued vitality of the rule-based international order. The high levels of public trust in these institutions is also worth noting. A 2020 public perception survey by MinLaw found that there is a strong positive perception of our legal system and institutions amongst Singapore residents. 95% of respondents agreed that we are governed by the rule of law. 90% had trust and confidence in our legal system and agreed that we had an efficient legal system. Around 90% had a positive view of our courts and of AGC. On the world stage, in Heritage Foundation's 2021 Index of Economic Freedom, Singapore achieved the highest scores amongst 184 countries for judicial effectiveness. The World Economic Forum placed Singapore first in its 2019 Global Competitiveness Index in terms of the efficiency of its legal framework in settling disputes. So this is not an exercise in theory or just in ranking numbers, but an exercise in building an institution that can actually deliver justice. The COVID-19 pandemic that we've just been experiencing and we're still in has shown the depth and excellence of our legal service. LSOs in both the judicial and legal branches have worked tremendously hard to deal with the challenges brought about by COVID-19. LSOs in the legal branch provided crucial legal support to the government response to the pandemic. In January 2020, AGC stood up a cross-divisional task force staffed by LSOs from the AGC and the legal divisions in various ministries to provide urgent cross-cutting advice to the government on all areas of the national pandemic response. For example, establishing government quarantine facilities, contact tracing, border security, ensuring continued trade flows for essential goods and services and supplies, financing the various COVID response budgets, and also vaccine procurement. In the first half of 2020 alone, AGC received over 1,300 COVID-related requests for advice. It responded to 69% of these requests within 24 hours and 78% of these within 48 hours. So it's not just the quality, but also the speed of the responses from our officers. LSOs, including drafters from AGC, work closely with policy officers in many ministries as well as with private sector representatives, to roll out a series of urgent measures to mitigate the economic impact of the pandemic on individuals and businesses. And these measures, which required major pieces of legislation to be drafted in record time, included, and I think members will recall over the last 18 months, the temporary relief from contractual obligations, a rental relief framework done more than once, simplified frameworks for financially distressed companies to liquidate their businesses or restructure their debts, and a framework for the negotiation of contracts affected by the pandemic, all novel pieces of legislation. The quickly drafted legislation also allowed the government to quickly implement new measures to control the spread of the disease. When circuit breaker measures were imposed to stop the spread of the virus, LSOs in the courts, AGC, and MINLAW, with other officers in the various agencies, worked together to formulate legislation to ensure the continued and undisrupted access to justice in spite of the pandemic. The courts operationalized a framework for remote hearings, developed a wide range of pandemic-related protocols. This ensured continued undisrupted access to justice, even in the middle of the pandemic. To enforce the Infectious Diseases Act and COVID-19 related legislation, prosecutors work closely with law enforcement agencies to assess the evidence and take quick action in all cases. On the international front, LSOs in the International Affairs Division ensured that our COVID-19 measures remain consistent with our international obligations. As the situation improved in Singapore, they also assisted the government in negotiating essential travel and air bubble arrangements to sustain economic exchanges and maintain our relevance as a regional and global hub. So these are just a few examples of the many contributions of the legal service in ensuring the fair and efficient administration of justice in Singapore during the pandemic. So what I've just outlined has been the model that we've adopted since Singapore achieved self-government. It has served us well to build up a legal service into the excellent institution that it is today. And I think members will agree that Singapore has benefited immensely. Over the years, the government has considered the question of whether an integrated or a specialist service would best serve Singapore's needs. We recognize the pros and cons both ways. The challenge has been and continues to be finding the right balance for our own circumstances, our own context, and our needs. As mentioned, the small talent pool has been a constraint, and that's something that we keep in mind as we consider the options. In July this year, member Mr. Murali Pillai, with the support of other members, spoke on this matter in Parliament, calling on the government to study the feasibility of setting up a separate JSC for judicial officers. Several members spoke. They made good points about the increasing need for specialization, including for the judiciary, given the increasing factual and legal complexities of the cases presented to court. Minister Shanmugam agreed with our observations that the benefits of specialization are likely to continue to grow as the legal service continues growing and maturing as an institution. After studying the matter further and discussing the matter in detail with the Chief Justice and the Attorney General, the government decided that we can take this step. As Minister Shanmugam has said recently, the amendment is a finely balanced one. You can make a good case for not changing now and waiting. However, you can also consider the following. The legal service has since 2014 also grown significantly. It had, as of July 2021, 815 officers. Although this is still a relatively small number in context, it will allow us to have specialist services whilst retaining the benefits of the integrated model through a system of secondments. Officers today have many opportunities to gain meaningful exposure and develop their careers. Since 2014, both the judicial branch and the legal branch have made various changes to deepen specialist skill sets. There has also been a significant emphasis on the training of our judges to develop specific competencies required for the judicial role. In 2015, members might recall, the Singapore Judicial College was established as the central training body for the judiciary. The state courts and the family courts also run their own training programs to help their judicial officers develop both deeper subject matter knowledge as well as the necessary practical skills. At AGC, the AGC Academy was set up to take charge of managing the training for AGC officers. Competency frameworks were developed so that individual training roadmaps could be drawn for each officer according to their own area of practice and specific level of expertise. The Academy also organizes regular workshops and lectures by subject matter experts in both core and developing areas of the law for AGC officers. Cross-departmental clusters and specialist tracks have been established to help build expertise in particular areas of law. So the proposed restructuring will build on these efforts, better support specialization of roles and competencies required of LSOs. Each commission will focus on the particular demands of their respective services. They will have flexibility to adapt their personal management and development frameworks according to their own specific, respective services' specific needs. The shift to a specialist model is not so much to address the problems of today, but really a matter of forward planning, preparing for the challenges of the future. As Minister Shanmugam said in his response to Mr. Murali's motion, the key question is, when is the right time to move? We could take a wait-and-see approach, given what I've said, and maintain the current system and make small adjustments at the margins, smaller tweaks. Or we can make the move now, prepare ourselves for the future. We believe this will eventually make sense to split the two services when the legal service grows further. So I'll now take members through the key provisions of the bills, starting with the Constitution of the Republic of Singapore Amendment Bill. Broadly, the new provisions seek to replicate the existing provisions in respect of the current LSC, with appropriate adjustments to be made when necessary in introducing the JSC. Clause 6A, read with Clause 26(1), establishes the Singapore Judicial Service. It will consist of existing LSOs holding posts in the Supreme Court or a subordinate court. All other LSOs will remain in the reconstituted legal service. Clause 14 inserts new articles to establish a JSC and to reconstitute the LSC. The new articles 111B to 111I relate to the new JSC, while 111J to 111Q relate to the reconstituted LSC. The composition of the commissions is set out in the new articles 111B and 111J of the Constitution. Each constitution will have two ex officio members. CJ will be the president of the JSC, and AG will be the president of the LSC. Chairman PSC will be the ex officio vice president of both commissions. The key change here is the hard coding of Chairman PSC's role as vice president in both commissions. Other than this, the remaining provisions replicate the current position in the Constitution. So the respective presidents of the commissions, Chairman PSC, and the Prime Minister may nominate up to two members whose appointment is subject to a presidential veto. Where any of them nominate two members, then at least one of them must be legally trained and of adequate seniority in order for both to be appointed. The existing disqualifications that you see today will continue to apply. Similar to today, personal boards or PBs may be established to exercise certain functions of the two commissions. However, there will be some structural changes to the PBs, which I will take members through. In 2014, members will recall that I said PBs were restructured along branch lines instead of by seniority. This was part of a broader shift towards specialization, as I mentioned earlier. The two PBs that have been operating since 1995 were replaced by the Judicial Branch Special Personnel Board and the Legal Branch Special Personnel Board, which have been in operation since that time. These two new PBs respectively oversee most human resource functions in respect of the LSOs in the Judicial Branch and LSOs in the Legal Branch up to Superscale Grade 3. Officers at Superscale Grade 2 and above continue to be overseen by the LSC directly. The two boards also oversee career development pathways in the legal and judicial tracks. The boards are currently constituted as such. Both are chaired by CJ, who is president of the LSC. The Judicial Branch Special Personnel Board comprises CJ and 3 other Supreme Court judges, and the Legal Branch Special Personnel Board comprises CJ and senior members of the AGC, including the AG and a Supreme Court judge. As part of the review, we also reviewed the appropriate structure for the PBs in the context of the changes that we seek to make for the proposed specialist model. With the restructuring, we have decided, following discussions with both CJ and AG, to shift to a system of formalized delegation. The structure of the commissions already align authority and responsibility, reducing the need for devolution. CJ and AG, as presidents of their respective commissions, will be closely involved in the management of their offices in their respective commissions. They will each be able to nominate Supreme Court judges and Deputy Attorneys General to the Commission, if they so choose. Both offices are involved in the management of the organizations and enjoy constitutional protection for their independence. A system of formalized delegation will facilitate alignment of purpose and efficient decision-making, and also facilitate the division of responsibilities between the commissions and the PBs. Post-restructuring, the sizes of the services will also be smaller, about 200 plus officers in the judicial service and 500 plus for the legal service. Under this proposed structure, commissions will be empowered to delegate, by way of subsidiary legislation, stipulated functions and powers to one or more of the PBs. These are to be exercised under the Commission's direction and control. In terms of composition of the PBs, the articles set out a close list of persons who may be appointed as PB members. There is also a requirement that PBs must have at least 3 members to ensure a diversity of voices within a PB and to bring balance to its discussion and decisions. Safeguards at the same time will be retained. The commissions may not delegate functions and powers relating to either senior officers at or above a threshold grade, and 2, discipline and dismissal of any officers. So both of those remain non-delegable. As is the case today, these matters will be decided at the commission level because matters relating to senior officers should be decided directly by the commissions, and functions of discipline and dismissal have serious professional implications and consequences. The appointments of members to any PB remains subject to the President's concurrence, as is the case today. Cross-service secondments will continue to be available on application after the restructuring. I mentioned cross-service secondments earlier in my speech. Those will continue to be available. And to facilitate this, Articles 111F and 111N for JSC and LSC respectively allow them to make joint regulations to provide that their personal management functions over officers holding prescribed posts may be exercised by the other commission. Secondments will be available under a framework jointly developed by the 2 commissions, and such movements will likely be subject to the prevailing rules or requirements developed by the 2 commissions, the needs of the services, obviously, given the specific manpower needs, including the availability of positions, and necessarily the officers' relevant experience and suitability for the job. So before I move on from the Constitution Amendment Bill, let me just briefly draw members' attention to clauses 21 and 22 of this bill. These clauses don't relate to the commissions. These clauses amend the references in the Constitution to various statutes relating to government borrowing. The changes are consequential to the amendments made in the Government Borrowing Miscellaneous Amendments Bill, which was just debated.